My dear friends, today we shall talk about on the topic lease, which is in our Transfer of Property Act in Chapter 5 from Section 105 to 115. This video will be great for law students who are first time learning the concept and also for the students who are practicing and revising the concepts. In this video, we shall talk about what is lease, what are the different types of lease, and the rights and liabilities of lessor and lessee, and also the modes of termination of lease. After you complete the video, I am sure that you will have an overall grasp on the topic and that will grow your confidence. So let's begin. First question that comes to our mind, what is lease? Lease is a transfer of the right to enjoy, and that is to enjoy an immovable property for a certain period of time, and the enjoyment is in consideration of a price. That price may be in cash or in kind. It may be paid, or promised to be paid. Now, the legal term of the price which is paid in lease is called premium. Now, what is premium? Premium is like a one time payment, it is like a security. There are two parties in a lease, the person who is transferring the property or the transferor, or here we shall call him the lessor, and the person to whom the property is transferred, which we generally know as the transferee. Here in lease, we shall call him leasee. In this scenario, the lessor gives you the land and the lessee gives you the price. Now, the price, as we have already discussed, the lessee may periodically pay, or time to time pay, or in interval pay the lessor. Now, that money or share of crops or service or any other thing of value is also known as rent. So, we have come across four legal terms: first, lessor; second, lessee; premium; and rent. Now, the purpose of the lease may be for agriculture or for manufacture or for any other purpose. Generally, in agriculture and in manufacture, a lease is made on a year to year basis, where there is 6 month notice period for the termination or end of the lease, and the other kinds where a lease is done for any other purpose, it is made on month to month basis, where the notice period is 15 days. Now we are going to talk about the modes of creating lease. Lease can be created by two methods. First, where registration is a mandatory procedure, and second, where registration is optional. Now you have to understand, when a lease is done for a short period of time, then the registration is optional. For example, lease for month to month basis, or lease for a term of 1 year only, or lease for a term of less than 1 year. On the other hand, when a lease is done for a longer period, then it needs registration. For example, lease from year to year basis. Here, the renewal will be done on year to year. After completion of each year, the renewal will be done. Each and every renewal registration is compulsory. Lease for a term exceeding 1 year. It can be 1.5 years or 2 years. And then lease reserving an yearly rent. Here also registration is mandatory. And in the last case, in permanent lease, registration is mandatory. Now here the student can have a confusion. Here we have talked about permanent lease, but as we know from the definition of lease, a lease can be made for a certain period only. Then why this permanent lease? Actually, it is a type of exception. In a permanent lease, there are certain terms and conditions which are written in the lease deed that after the demise or death of the leaser or the lessee, the lease will continue and the legal heirs of lessor or lessee will continue to enjoy the lease. Here, no time period is fixed, but such kind of lease is bound by certain terms and conditions. So, naturally, we got a question here how a lease is terminated or ended. That is also discussed in section 111 of the Transfer of Property Act. There are certain methods upon which a lease can be terminated. First, by efflux of time or by end of the lease period. Now here a lease is done for a stipulated period and that period has been expired. And no formal notice to quit is required. And in case of a tenancy, if the period ends, there is no requirement of notice, and the landlord can file a suit for eviction if he wants. Second, by happening of certain event, when there are terms and conditions mentioned in a lease that a lease will be valid for contingent terms and conditions on the occurrence of a specific event, a lease will be terminated. Then, when that event occurs, by the happening of that event, that lease is determined. Now, the third method, if the interest of the lessor is ended, then the lease will also end. That means, let me give you an example. Now, a person has been given a property for life interest. That person gives that property in lease. Now, after 10-15 years, that person dies. When that person dies, because the property was in life interest, the interest of the lessor is ended. Now, when the lesser interest is ended, then the lessee has also to end his interest because the lessee's interest is dependent on the lessor's. The lease is terminated automatically. A lease can also end by merger. Maybe the property of the lessor and the property of the lessee, both their interest has been merged into a single individual person. A lease can also end by the method of express surrender of the lessee. When a lessee relinquishes the interest to the lessor. For example, there is a tenant and the tenant himself gives delivery of possession of his tenanted room to the landlord. Then it is express surrender on the part of the tenant. In this case, no formality is needed. It is done by the delivery of possession. A lease can also be terminated by implied surrender. Now, see what an implied surrender is. Two parties were having a previous relationship on a subject matter, and now there is a new relationship which has arisen, and these two relationship, the previous relation and the subsequent relation or the new relation, cannot coexist. When they cannot coexist, they are incompatible and inconsistent with each other. The former relationship expires on the creation of the later relationship. Suppose the former relationship was of the lessor and the lessee, and the new relationship is the seller and the buyer. Again, lease can be terminated by way of forfeiture. Forfeiture can be done by three ways. First, if the lessee breaches any kind of express conditions which was mentioned in the lease deed, or the lessee is renouncing his character and the lessee is claiming that he is the owner of the property. Now, this is not legal. So, the lease actually gets terminated. Again, by forfeiture, if the lessee is declared insolvent and there is any express condition mentioned in the lease deed that if you are declared insolvent, you have to give up the property. Now, in that case, by forfeiture mode, a lease can be terminated. And the last but not the least is on the expiration of notice period. So in the very beginning of this video, we have talked about in year to year lease there is 6 months of notice period. In month to month lease there is 15 days of notice period. Now when this notice period is expired, the lessee should vacate the property of the lessor as the lease is actually determined, terminated. We have come to the last portion of the video where we shall talk about the rights and liabilities of the lessor and the lessee. Now you have to use your brain a little bit and understand that right and liability is the two sides of the same coin. I want to say that the rights of the lessor is the liabilities of the lessee, and the rights of the lessee is the liabilities of the lessor. Now, the lessor, that means who is giving the property in lease, has certain liabilities. That is, he has to disclose the latent material defect on his property. Now, a patent defect can be seen by good inspection, but a latent defect cannot be seen with inspection of a ordinary prudent man. So the lessor has a liability towards the lessee that he has to disclose the material latent defect on his property. Now when he is giving his property in lease, he has to obviously give possession to the lessee. And when he is giving possession to the lessee, he has to take care of the peaceful enjoyment and ensure the peaceful enjoyment of the lessee. That means the lessor cannot or do not interfere in the leased property. Now, on the other hand, the lessee has certain rights. In addition to the above 3 points, the lessee has also some rights. First, if the property is increased or there is any kind of accession of the property, he has the right to enjoy it. Lessee can avoid the leased property in case of any kind of destruction. It may be by fire, by storm, by flood, etc. As the lessee is enjoying the property, he has a right to repair the property also whenever it is needed. And if the lessor neglects such repair, the lessee does it, he can deduct the expenses or recover it. Now, when the lessee is enjoying the property, he has to make the payments or whatever the taxes or revenue that is due on the property, and that also can be recovered from the lessor. And on a lease property, he can enjoy any kind of benefit on it, and with the permission of the lessor, he can do improvements or fixtures. But on the termination of the lease, the lessee has to remove the fixtures as well. The lessee can sublet or sublease, that too with the permission of the lessor. Now, when a lease property is subleased, the sublessee steps into the shoes of the lessee. And now the sublessee has to take care of all the terms and conditions of the lease. So these are the overall rights and liabilities of lessor and lessee in a lease. And now I am confident that you have been given some degree of clarity on the concept in the lease. It was wonderful spending time with you. If you have any kind of suggestion, do not forget to make a comment in the comment box. And to extend your support, please hit the subscriber button and give this video a like. You can check out my other videos also. Actually, I am making these videos for clearing my concept and my fellow law students' concept, and it is a mode of discussion. So please share if you feel anyone will be interested to join the discussion. Thank you so much.